Thanks, Mark. Like he said, my name is Chris, and I'm going to be the moderator for today's panel. A matter of disclosure at the start, I've written on the issue of Bill 21 and religious neutrality a fair bit. Suffice it to say that I'm not neutral when it comes to religious neutrality, but I'm going to, as much as possible today, step back and just facilitate the discussion between our panelists, and I'm hoping we can get some really good debate, possibly, and insight going. So I'll start with the panelist to my left, introducing him. We have Dr. Geoffrey Sigalet. He's a postdoctoral fellow at McGill's research group on constitutional studies and a research fellow at Stanford Law's Constitutional Law Center. He earned his PhD at Princeton in 2018, and his research interests include theories of judicial review, constitutional interpretation, and in particular, the idea of dialogue between courts and legislatures on rights. Seated next to him, we have Professor Leonid Sirota. He joined AUT Law School in 2016 after completing graduate studies at New York University School of Law. He'd previously served as a law clerk at the Federal Court of Canada, and he graduated from McGill with degrees in both civil and common law. His research and teaching focus is on constitutional law and theory and related areas, including the law of democracy and judicial power. In addition to his scholarly writing, he's also the creator of the Double Aspect blog, and I would hazard a guess to say that most of the readers in this room are readers of Double Aspect, which is a fantastic blog. And then seated next to him, we have Professor Bruce Pardy, Professor of Law at Queen's. He is our panel's wandering hedgehog. He digs around in environmental law, energy policy, property and tort theory, constitutional rights and freedoms, university governance, free markets, and the rule of law. He briefly practiced civil litigation at BLG in Toronto and has taught at law schools in New Zealand and the US, and he has served for a decade on the Ontario Environmental Review Tribunal. So I'm going to start for our panelists with what I think is a deceptively simple question, because I think the issue of Bill 21 is anything but simple, and people are coming at this particular issue from a number of different directions. So I think this opening question will just sort of set the stage and give us a taste of where our panelists are coming from on this issue. So the question is this: what issue do you see as being at the heart of the Bill 21 controversy? So we'll start with Jeff, and then we'll work our way down the panel.
Thank you, Chris. How close do I have to be to this thing for it to work? I see the central issue as a matter of religious freedom, and I think that the bill clearly violates religious freedom insofar as we think that religious freedom involves the free exercise of religion. The bill prevents members of the employees of the state of Quebec from exercising their freedom of religion by forcing certain individuals to not wear religious symbols, and I think that religious freedom is just at the core of the issue. The tricky part, and the reason this is perhaps a deceptively simple question, is that religious freedom is not going to be at the heart of the litigation necessarily, because Quebec has employed the Notwithstanding clause in this legislation in a way that insulates their law from challenges from judicial review under the Charter, Section 2A right to religious freedom. So instead, the litigation targeting it is using claims about Section 28. The Charter has two notwithstanding clauses in it. There's a notwithstanding clause in Section 33 that allows for legislation to be enacted notwithstanding certain sections of the Charter. Section 28 also has a notwithstanding clause that says, notwithstanding anything in this Charter, no laws will be enacted. That's not the way it was worded. Notwithstanding anything in this Charter, no laws should be. How's it worded?
Should I look it up?
Yeah,
You should.
You should look it up. Exact wording. It says, notwithstanding anything in this Charter, you will not violate sexual equality. And this was a part of the Charter introduced after Section 33 as a result of agitation by certain women's rights groups. And here we have the exact wording. Notwithstanding anything else in this Charter, the rights and freedoms in it are guaranteed equally to male and female persons. So this is our second notwithstanding clause, and it's one of the levers that's being used to litigate this law that's protected by the other notwithstanding clause in the legislation. So the core issue at stake here is religious freedom of exercise. That is protected by the Charter. But interestingly, sexual equality will become one of the main issues of the Charter litigation.
I don't disagree with what Jeff said. I think as this panel goes on, this will be a rare occurrence that I don't disagree with him. But I do think that it's important to take a step back. And I would say that the real issue here is not just about religious freedom in particular, but it's more about individualism and the value of individual and of individual liberty more generally as being the thing that we should care about and that the Quebec state does not care about. The Bill 21 is one example, but it's not the only one, of certain of prioritizing what you might call a sort of public aesthetic over individual liberty. Bill 101 does the exact same thing. It's the subordination of individual liberty to the alleged interests of the community, or more precisely, the alleged interests of a particular majority group within the community, and that those interests are deemed to be more important than the concerns of individuals. In this particular case, it's obviously the concerns that have to do with religion. In other cases, it's the concerns that have to do with their freedom of expression, their linguistic choices. But the underlying philosophical issues is common. It's the subordination of the individual to the community.
Well, if Leonid and Jeff are not going to disagree, then I will. The issue about Bill 21 is indeed the question of liberty. But it's not the liberty of the employees of the government. It's the liberty of the citizens. So you walk into a corner store, and the person behind the counter has his face covered. Might be a veil, might be a Darth Vader mask, but you don't want to deal with somebody whose face is covered. So what do? You walk out. You go to the next store down the street. That is your freedom to choose with whom you want to interact. But if you go not to a corner store, but to the driver licensing bureau or a court, you can't turn around because there is only one government. And so your liberty to deal with people who are not imposing religious garb upon you is limited by the fact that those people are working for the government. So to preserve your right not to deal with people you don't want to deal with wearing things you don't like, this bill is necessary for the liberties of the people who don't work for the government. Now, I'm not a huge fan of the law. It's not a law I would have passed myself, but I don't think its flaws are as critical, as crucial, or as unconstitutional as they're made out. I think the Charter, we'll get to this in a minute, I presume, but I don't think the Charter here should apply. I don't think it should apply at all. And perhaps we'll get into more of that as we go along.
Well, I think those answers show that we come at this from a number of different perspectives, and that's great. And so let's dive into that a little bit more, and let's try to unpack some of these issues further. So as has been mentioned, to date there have been 4 challenges that have been launched against Bill 21 on various constitutional grounds. The Quebec Superior Court recently directed that all 4 of these challenges would be heard at the same time. Now, starting with Leonid, do you anticipate that any of these challenges will ultimately be successful, either at the trial level or all the way up to the Supreme Court?
It's very hard, I think, to make predictions. We are in, because the obvious avenue of recourse against this legislation has been, for the time being, foreclosed. Remember that the Notwithstanding clause in Section 33 of the Charter only insulates legislation insofar as it insulates it for limited periods of 5 years. After that, has to be renewed. The current Quebec government is not going to be in office forever, although they probably will be in office for a while. So for the time being, that avenue is foreclosed. That means that we are, and it, in a way that it hasn't really been before, we are in uncharted waters, and it's very hard to say which of the challenges may or may not succeed. So there are the arguments that are being made, if I understand correctly, there is an argument based on Section 28, there is an argument based on the division of powers. Section 28, there is just not a whole lot of jurisprudence on it. So if you're asking about prediction, it's very hard to make a prediction on that. Prediction on the division of powers is that I don't think it's likely to succeed, although I have myself suggested that it should, or at least that there's a very serious argument there, but I don't know that the courts will take it as seriously as it deserves to be taken. I'm not sure if anyone is actually making the argument that Robert Leckie and company have advanced about the possibility of a declaration being made, a declaration that would not interfere with the operation of Bill 21, but which would at least signal that it's in violation of the Charter right to religious freedom. Again, that's a novel argument. I agree with this one too, but I don't think anything like that has really been tried before, so it's a bit difficult to say what its chances of success are.
Bruce.
I think they shouldn't succeed. Whether or not they will is hard to predict, because prediction depends upon the idea that the Supreme Court will do what the Charter says, and there's no indication that that is so. So let's talk about three different bases. Number one, I suggested earlier that the Charter shouldn't apply. Now, of course, there's lots of room for it to apply, and there's lots of statements, of course, that the Charter applies whenever you're talking about government, but there are also lots of statements that there are some circumstances in which the Charter should not apply. Let me give you one example. If you are a policy analyst for the government, and you want to write a column in the paper about the recommendations that you've made to the government, which the government rejected, and the government says, no, we don't want you doing that, can you say, well, my freedom of expression and Section 2B have been violated? No. You don't have freedom of expression rights if you are an employee of the government giving them policy advice. That doesn't make sense. In the same way, it should be within the power of the government as an employer, not as the government, to give you guidelines about what you're allowed to wear when you're a frontline staff dealing with the public. But let's assume for a moment that the Charter does apply. If it does apply, or would otherwise apply, and the government of Quebec has put Section 33 in the bill, well then, freedom of religion, obviously, should not apply. That is the straight-up wording of Section 33. So that should do away with all those arguments, with the exception of Section 28. Now again, if you look at the words of Section 28, it suggests that Section 28 should not apply either in the face of Section 33. Why? Because Section 28 simply guarantees that the rights are guaranteed equally to men and women, while the rights we're talking about are in a section of the Charter that Section 3 has now excluded. So those rights now do not apply equally to men and women. So my take, if I was on a bench hearing these cases, is, sorry, free sailing for Bill 21.
All right, Jeff.
Well, I have the temptation to start arguing with Bruce, but I'll try to stick to the point. I think that the of the arguments put forward. There's also a Section 23 claim, I think, put forward by the English Montreal School Board. I think that's probably based on the interference with language rights, which the Section 33 doesn't apply to Section 23 either. I think that's probably the thinnest argument made against this bill. The section, and so the least likely to convince the court, the Section 28 claim, I think has the possibility of, there's this disparate impact arguments. The argument is that this bill does, it is insulated from review in relationship to Section 2A religious freedom claims, but it's actually subject to Section 28 because it will disproportionately impact Muslim women. Because obviously one of the chief religious practices it's forbidding is the wearing of the veil or the hijab. I think that so the idea was that this disparate impact violates the guarantee of sexual equality in 28. What's interesting about that is, and one of the reasons it might not convince the court, is it seems to twist the right to religious free exercise in a way that turns it, that potentially twists what we might understand as the scope of 2A itself. So we traditionally think of free exercise as also involving the right of religious institutions to discriminate within their own organizations in different ways that might not be acceptable in other contexts. So we accept that having male-only Catholic priests or Muslim clerics is part of free exercise, what we would think of as common sense free exercise claims. And that seems very obviously at odds with Section 28's guarantee insofar as we understand it as this very strong substantive right that needs to be the prism through which you read every other right in the Charter. So I think one reason the court might shy away from the Section 28 argument is because it has that, it seems to have this potentially distorting effect. I think you see the court also generally is just being the courts will be a bit skittish about ruling about Section 33, given that it's an interesting technical legal argument to say that they have anything to say about it at all outside of these very specific Section 28 and Section 23 claims. The other argument will be, do they have the ability to make a declaration that the rights under 2A have been violated, given that the right to a legal remedy under the Charter, Section 24, is not subject to Section 33. I think that argument, it's a very interesting, brilliant argument made by Gregoire Weber, Dean Leckie, McGill Law School, and Eric Mendelsohn. This is a brilliant argument. I think that it might not convince the court merely because there is this idea that once the legislature has invoked Section 33, the whole point of Section 33 is for the legislature to have some say and be able to disagree about the nature of charter rights in a way that suspends the judiciary's ability to invalidate its provisions, invalidates its enactments. And I think that signals that there's some measure of respect and deference owed to a legislation employing Section 33, and the court will follow the trend of its decision in Ford, and my prediction is that they'll be fairly deferential.
Let's dive down actually into that issue a little bit more next. So obviously Section 33 has a 5-year timeline. Leonid, you were mentioning that earlier. So in your views, is a declaration that Bill 21 violates the Charter on its face, would violate either Section 2A or Section 15 in a way that could not be saved under Section 1, but is nevertheless saved by Section 33. Would such a declaration be useful even if the law is ultimately not struck down?
Chris, can you pull up the text of the Section 33 as well?
Yes, I can.
And just read it to us?
This is the text of Section 33. Parliament or the legislature of a province may expressly declare in an act of Parliament or of the legislature, as the case may be, that the act or provision thereof shall operate, notwithstanding a provision included in Section 2 or Sections 7 to 15 of this Charter.
And 33.2?
I'm not sure if it's here on this page. Hang on a second.
I think this 33.2 is the really key provision here.
This shall have effect.
Yes.
Give me a moment here while I try to find it.
It's too bad we don't have pocket constitutions in this country.
You can get them for free at the Museum of Human Rights, but I didn't bring mine with me. Here we go. Section 33(2). An act or a provision of an act in respect of which a declaration made under this section is in effect shall have such operation as it would but for the provision of this charter referred to in the declaration. So maybe we'll start with Bruce and then we'll work our way back around.
All right, so the question is whether it would have value.
Yes.
A declaration would have value. Well, I suppose only in the battle between people who disagree about whether or not Section 33 should have been used, really, because it's not going to have any legal effect. So symbolic only. And so the question really is whether you want your courts to be telling the legislature it's done a bad thing, even though the legislature has done exactly what the charter allows them to do. Right? Section 33 is as much a part of the charter as Section 1 and 2 and 7 and 15. And there are some commentaries that suggest that the use of Section 33 is illegitimate. Well, if Section 33 is illegitimate, then the whole damn thing is. Because Section 33 is part of the deal. It's the last remnant of legislative supremacy. And my goodness, the courts have taken on their role of judicial supremacy with gusto. So you might think they'd give this one at least the reading that it's due. So, yes, I suppose the parties might seek a declaration just because, to show, the legislature that it's done a bad thing, but I don't agree that it has done a bad thing. If Section 33 is properly used and properly ousts the application of these other charter sections, well then, how can you possibly say the legislature has done wrong?
And I should clarify that the point of the question was that Section 33 obviously has a limited lifespan each time it's used. It has a 5-year limit, and every 5 years that has to be renewed. So the argument has been made that in theory you could have a declaration that the law would have violated the Charter, but for Section 33, and then if the government chooses not to renew Section 33, then at that point the law would become unconstitutional and could be automatically struck
Well, that might
down.
be helpful for everybody in the sense that if the court would hold that the Charter doesn't apply anyway or it doesn't violate the Charter, then the government would know they didn't have to renew the application of Section 33. So that might be a helpful thing for everybody.
I think an interesting, where there are declarations of invalidity, and part of the hook of the argument that there should be such a thing in the Canadian context is that the statutory bills of rights, well, the Human Rights Act in the United Kingdom explicitly has a section, Section 4, that enables gives discretion to the courts to make declarations of the inconsistency of ordinary parliamentary legislation with the European Convention on Human Rights that's incorporated into law by the Human Rights Act. And whenever there's been a declaration, except in one very prominent case in the United Kingdom's context, the Parliament has, or a minister of the government has taken advantage of another part of that legislation that enables a minister to enact secondary legislation rectifying the rights violation that the court has declared. The point being that many of the declarations that have been made in the United Kingdom context have elicited a legislative reply. And so it's possible to think that might happen here. I think in the context of Quebec, we've got to keep in mind, and I think it's important to keep a respectful discourse, where many Quebecers don't see, I said this issue is about religious freedom and religious free exercise. Many Quebecers would agree it's about religious freedom, but then think of religious freedom as better conceptualized in terms of laïcité, in terms of a strict understanding of state neutrality along the lines of what Bruce is saying. And that's another conception of religious freedom. And it's very popular in Quebec, partly given their historical circumstances. And they will, I think, not take kindly to a court pointing out that the Charter and the way the courts have interpreted free exercise is an alternative understanding of religious freedom that's quite at odds with theirs. I don't think it will matter very much. They already know that. But I'm not sure. I think that Section 33's expiry does not signal legislative supremacy in the Canadian context as much as it points to a shared role for interpreting charter rights between the legislatures and the Parliament post-charter. And one interesting aspect of a declaration of incompatibility that has no legal effect, like the United Kingdom's, will be, an interesting side effect would be that the court would be explicitly actually recognizing that there's a role for ordinary legislation to specify rights. In a way, by implying that the legislation does not properly specify and protect rights, they would be implying that Section 33 could be used to properly protect rights by suspending judicial invalidations of legislation about rights. So it would be an interesting, even though it would also be potentially grounds for asserting more judicial power, it actually might also include a concession to the wider, more legitimate use of Section 33 in other contexts to protect rights, like in the Saskatchewan case. But we'll talk about that in a bit, maybe.
So I'll bring in the New Zealand perspective. The New Zealand Bill of Rights Act is also a statutory Bill of Rights, which actually served as a model for the UK, but it did not include any provision about remedies. And the government that enacted it said, oh, we're not creating any new remedies for the courts to grant. The court said, great, we're going to just grant the old ones. So they were miles ahead of Canada in terms of granting damages for violations of the Bill of Rights Act, for example. And more recently, there was this question of declarations of inconsistency, which are, again, not explicitly provided for, but the courts at all levels of court in New Zealand, including the Supreme Court, have said that, no, there is a value to those declarations. They are a form of remedy that the courts can grant as part of their inherent powers in the New Zealand case. Now, the courts have somewhat disagreed with one another about what exactly the purpose of those declarations is. The Court of Appeal said that declarations are a form of dialogue with Parliament, that they're a sort of way for the courts to address themselves to Parliament, to speak to Parliament, speak truth to power, if you will, and say, you guys need to revisit this thing. They don't necessarily have to agree with the court, but they should at least, according to the Court of Appeal, they should at least revisit this thing. The Supreme Court said, no, this is not how it works. It's not a matter of us engaging in some kind of discussion with Parliament. We are telling the person whose rights have been infringed that they have indeed been infringed. It's a remedy for the claimant. And in the Canadian context, I think this argument is that much stronger because of Section 24. I think that actually I made that argument first. I don't think it was Dean Leckie and Grégoire Pébert.
Section say that it was.
Section 24 says that the courts have to grant such remedies as are just in the circumstances for violations of the rights that are protected by the Charter. Now, Section 33, there's two important things about it. One, it shields operation. It's not a provision that, by its text, says that the government can suspend rights. It says that the legislation in respect of which Section 33 has been invoked has such operation as it would but for the rights. But the rights are not suspended. They're still there. And Section 33 does not apply to Section 24, which is the remedies provision. So, as I read the Charter, as just a matter of text, when Section 33 operates, the other rights are still in place. A particular remedy, that is to say, any remedy that interferes with the operation of legislation, is pushed aside. It's no longer appropriate in the circumstances, as Section 24 has it. But other remedies that are appropriate, that are consistent with the judicial role, other remedies are still there. And the declaration of inconsistency, as those New Zealand cases suggest, now the Australians take a different view. The Australians have a very narrow view of what the judicial function is. I don't think the Canadian view of the judicial function is the same. So I think Canada is closer to New Zealand in this respect, and it would be an appropriate remedy under the circumstances, addressed primarily to the persons whose rights have been infringed. But it does have those other uses as well. It does have the use of, if, and that's quite possible that Quebec government, a differently constituted Quebec government, will just not have the guts to actually repeal Bill 21 as they should, but they will instead say, oh, well, we're not going to renew the declaration we're not going to renew our resort to the notwithstanding clause, and we'll let the courts do the dirty work. Well, this will do the dirty work in advance so that on day one the rights can be restored. So there is a practical value there as well, but above all, it's a remedy that is addressed to the person whose rights have been infringed, and that's what Section 24 of the Charter requires the courts to do. The courts are asked to provide remedies for the person whose rights have been infringed.
A few of you have touched on this idea of dialogue, so let's maybe talk about that for a brief moment. In this case, the invocation of Section 33 is anticipatory. So there hasn't been a declaration yet that Section 21 has violated the Charter. So in essence, what the Quebec government might be said to be doing is saying, we know that this piece of legislation does or is likely to be found to violate the Charter. We simply don't care, and we are going to allow this to operate regardless. Is that an appropriate use of Section 33, or should it be reserved for what the late Peter Hogg would have referred to as sequel legislation after a law has been struck down and Parliament comes back with a new law and they insulate it against judicial scrutiny by saying this is what we think is the appropriate response to the ruling that you gave? So Jeff, I'll start with you on this one.
So I substantively disagree with the use of the notwithstanding clause to override religious freedom rights as I understand them. I, in a second order, do not see anything wrong with using the notwithstanding clause to anticipate a disagreement with the judiciary about the nature of charter rights and how they apply to a public policy issue. The point of Section 33 is to allow the government to do exactly that. An elected is to preserve, as my fellow panelists have kind of pointed out, some measure of legislative supremacy, but to temper that by opening it up to potential, eventually the legislation has to be reviewed to become permanently constitutional law. So it has a coordinate aspect. Even if the government opens up like this and anticipates disagreement with the judiciary, if they want their conception of rights to eventually become permanent, at some point they're going to have to win litigation or just perpetually keep using the notwithstanding clause. But it signals a kind of coordinate nature, I think, the expiration, and I think it's important to distinguish our ability to use Section 33 to disagree about rights from whether or not we think specific uses are correct or not.
I think, as a first order thing, that it's never legitimate to use Section 33. Never, never, never. The fact that it's in the deal doesn't mean anything. It means it's legal. It doesn't mean it's legitimate. The disallowance power was in the 1867 deal. It's, I guess, still legal. It's still there. It would not be legitimate. Same thing for Section 33. Now, if you think that it is legitimate to use Section 33, then I don't really see much of a difference between using it in anticipation or in response. I mean, the Quebec government, if, let's say, this was being done in 1984, and forget the legislation that imposed Section 33 on everything at that point, they would maybe not have invoked the Notwithstanding clause, and they would have said, we have a defensible conception of religious freedom, and we will fight this out in the courts. And they maybe would have lost. We are not in 1984 anymore. We've had 30 plus years of charter jurisprudence. The lawyers for the Quebec government can read it as well as all the rest of us. And they've told the government, look, this is not going to survive a second if it goes to court. So the government says, all right, we're going to insulate it. Or they try to insulate it anyway. So it's, if you believe that Section 33 is some kind of dialogue, well, yeah, they are engaged in this dialogue anyway. They don't have to wait for this particular statute to be struck down because they know it would be, because they're already, in a sense, responding to all the previous decisions of the Supreme Court. Again, if you think that it's legitimate to use Section 33 at all, I don't see why you wouldn't use it in this particular fashion.
Okay, so let me respond to those comments from Leonid, because I think this notion lies at the heart of this question over Bill 21 and Section 33 in particular. For those of you who are inclined to not believe in the generous use of Section 33 because it will undermine your charter rights, your liberal, negative freedom charter rights. Let's look at the big picture for a minute. Those rights have already been undermined. This liberal, I mean liberal in the original classical sense of the word, this liberal document, at least as far as I'm concerned, the charter was drafted and intended to be a charter of liberal freedoms. That is, negative freedoms preventing the state from interfering with you. Those freedoms and that charter has already been undermined. It's been undermined continuously by the Supreme Court, almost from day one. It is being transformed from a liberal document into a progressive blueprint. Section 1 is big enough to drive a truck through and legitimizes the courts taking on the role of being the final arbiter of social policy. That's not a liberal document that protects rights. Section 2B, freedom of expression. Section 7, Section 15. Section 15 does not guarantee, according to the court, does not guarantee the equal application of the law. It requires equal outcomes. It's substantive equality. So the court, and the Supreme Court in particular, has taken on the role of undermining the premise of the whole document, as far as I'm concerned. And Section 33, frankly, is one of the only things left. Thank God Section 33 is in the Charter. If I was the Premier of a province, I would, as a matter of course, say, we're putting Section 33 in every single statute we're going to pass, as an indication to the court that you have exceeded your role, and we don't approve of what you're doing to our charter. It's not yours, it's ours. It belongs to the country, and you are fashioning it in your image. And the only tool we have left is to say, get your hands off this statute. And I think that's appropriate now every single time.
Jeff, I sensed that you disagreed with part of Leonid's answer. Do you want to do a 1-minute rebuttal?
I'm just feeling very moderate now. I'm not used to feeling this way. I think that in between using Section 33 always and using it never, I have this odd view that it could be used to construct rights in ways where courts, we might reasonably disagree about how a court has ruled about the limitation of a right, or how to conceptualize a right, for that matter. And they often conflate the two, and this has contributed to some of the difficulties we have in Canada, I think, in our dialogue. I think we can contrast, and this is where Leonid and I disagree traditionally, and have debated in public, I think, before, is that we can use Section 33 very surgically at times in either the anticipatory or the sequel sense. And I think we can contrast the use of Section 33 by Saskatchewan to respond to a judicial ruling that held that religious neutrality required no funding for non-Catholic students at Catholic schools. The legislature rightly pointed out that this was a highly controversial conception of religious neutrality and the requirements of it. And it enacted legislation disagreeing with the court's understanding of how Section 2A related to public funding that is otherwise protected for Catholic students, and to protect funding for non-Catholic students at those Catholic schools, extending choice to parents as to whether or not they want to send their kid to a Catholic school that's publicly funded or a non-Catholic school. That's a use of Section 33 that enacts a conception of charter rights at odds with a decision that's controversial and debated by scholars like me and Leonid. And in a democracy, we should have the option of disagreeing with our courts when they make these kinds of controversial decisions. And I think it's extreme to say, on the one hand, that we should never use the notwithstanding clause, because this is a clear example of, I think, where there's reasonable disagreement and the outcome is more democratic for having used Section 33. On the other hand, the Charter represents democratic negotiations between the provinces and the federal government about what rights to protect, what rights matter fundamentally to Canadians as rights against their government. And in spite of, I think that Bruce and I might agree about some decisions and disagree about other decisions, some outcomes, some interpretations of rights and others, we've entrenched and made a democratic choice to have this Charter of Rights and Freedoms. And surely the judiciary has some role in saying what they mean in specific cases and contexts. That does not mean that the legislature has no role. It means that courts have some role. And using Section 33 across the board would signal that these rights are not, that the judiciary has no role in that regard. And I think that would be extreme in the other way. Sorry, I took more than 1 minute.
That's okay. Leonid, you want to do a sub-rebuttal. Go ahead.
So I'll also speak to the Saskatchewan case because I think it does illustrate the issues with Jeff's argument. The Saskatchewan case said, so we have to understand what it did decide and what it didn't decide. Saskatchewan has a constitutional obligation to fund separate Catholic schools. The question, and it funded those separate Catholic schools, including for non-Catholic students. It did not fund, on an equal basis, any other religious separate schools, which it could have, but it didn't. So what the court decided then was that so there was no constitutional entitlement for non-Catholic students to go to Catholic school. That entitlement only exists for Catholics. Non-Catholics don't have the constitutional right to it. Now, if the Saskatchewan legislature wanted to grant them this right as a matter of statute, it had to grant the same right to students who wanted to go to other schools, including the non-Catholic ones. That's the religious neutrality issue. And the government of Saskatchewan could have responded to that decision by saying, oh, yeah, sure, we are going to fund on an equal basis all kinds of religious schools. They didn't do that. Instead, they have made a big show of respecting religious neutrality, but what they do is they continue to fund Catholic schools on a preferential basis. I'm sorry, that's not a reasonable conception of neutrality at all. And that's what's going to happen with Section 33 time and time again. It's going to be used not to protect liberal views, as Bruce suggests. I mean, if we had genuinely liberal governments in this country and the courts were the bulwark of this retrograde conservatism, maybe I would feel differently about that, but that's not what we have now. Our governments are not liberal. Quebec is only the most shining example of deep-rooted illiberalism, but it's by far not the only one. And the courts have obviously been very imperfect, although perhaps I also don't think that they've been quite as bad as Bruce has suggested. But the reality of what's going to happen if Section 33 is used is, if Saskatchewan is your poster child, the privileging of Catholic schools over all others, I rest my case.
Can I respond to
Yes, absolutely.
So, I think that point is quite right. You're going to have a mess. If legislatures do as I suggest, and they're not going to, but if they did use Section 33 as a matter of course, it would be a mess. The Saskatchewan case is a good example of, I think, a court getting it right. I like that decision. And I don't like what the Saskatchewan government has done. And if I had my preferences, it wouldn't do what it's doing, including using Section 33. But that's about content now. And the fact of the matter is, the whole thing is already a mess. And the situation you have now is that only the courts get to say what's going to happen. And the Section 33 point is simply not that the legislature is always going to be right. Legislatures get it wrong all the time, too. I totally agree with that. I agree with the point that they're not bastions of liberal freedom either. Totally agree with that. But the problem is, it's all one-sided right now. You've got courts declaring what shall be done. Again, as I said before, saying openly, we are the final arbiters of social policy. And my only point is, that is untenable. If that's what the Charter has meant, that means the Charter is now essentially, in my view, illegitimate, because it has overturned our system of government, essentially. And in order to make a mess again, you're going to have to bring the legislatures back in with a real voice about what is constitutional. And so this is not going to be clean in any way. I take the point, but I think the way we've gone has been bad news.
All right, next question. I'd like to read Section 26 of the Charter for you all. Section 26 says, "The guarantee in this Charter of certain rights and freedoms shall not be construed as denying the existence of any other rights and freedoms that exist in Canada." So my question is this: are there some principles and freedoms that are so fundamental to our Constitution and our understanding of the Constitution that they must fall out of the scope of Section 33? To put it differently, are there enforceable constitutional rights which are guaranteed outside of the text of the Charter and to which the Notwithstanding clause cannot apply? So, Leonid, we'll start with you on this one.
Well, this is a bit of a curveball. I actually plan on eventually writing about Section 26, but I haven't done that work yet, so I'm not sure I have a meaningful answer. I think as a very preliminary matter, what I will say is that maybe there are other rights that are beside those that are explicitly guaranteed, and maybe as a further step, the courts could even enforce those rights against legislation. And those two things are not necessarily the same. In the United States, the Ninth Amendment, which has a similar text, there are different views on what it means. So Randy Barnett, who was here yesterday, argues that it does protect unenumerated rights and that the courts can invalidate legislation that trenches on those rights, and he has a sort of list or definition of what those rights are. Michael McConnell, who's another scholar, if Mark, maybe next year you can bring Michael McConnell here, that would be really awesome. So his view is a bit different, and he says that it's the Ninth Amendment protects something like a principle of legality, so that if Congress or the states want to infringe on those unenumerated rights, his list might be quite similar to Professor Burnett's, but he says they can trench on them, but they have to make clear statements. So maybe that's a better view of what Section 26 is. I don't know, that's just a hypothesis. But all that to say, so there might be unenumerated rights that sit beside those that are in the Charter. But I don't think that Section 26 can be read to protect rights that sit, as it were, underneath or somehow deeper than the ones that are listed in the Charter, such that Section 33 cannot erase them and they still endure even if Section 33 has been invoked. So is there some kind of uber right to religious freedom that sits, I don't know, underneath or above Section 2A, and Section 33 can only be used to set aside religious freedom, the ordinary sort, but not uber religious freedom? No, I don't think that makes sense. I don't think that's right. Bruce?
Yeah, I think that makes sense. I agree with that. If we see it any other way, it's an invitation to the court to do other than what the text of the Charter says. Yes? So these other rights that might exist out there in the ether are either rights that are unwritten constitutional principles or they're common law rights. Now, if they're common law rights, of course, they can be abridged by statute, so that's not a constitutional question. And if they are unwritten constitutional rights that have not been identified yet, well, you're just inviting the court to do what it's been doing, which is to make stuff up, and thereby defeat the valid use of a section of the Charter that says that legislatures can override these rights set out in the Charter. So on that, I agree.
Jeff?
In my experience, Michael McConnell is right about most things. And I think that his understanding of the Ninth Amendment probably applies to Section 26. It's just probably stands for, and I'd have to do some more work on this, and so my answer is very preliminary, but it probably stands for something like the principle of legality in Canada as well. It's signaling that there are other rights that were not entrenched in the Charter because people disagreed significantly about them, but that didn't mean that they weren't important rights, and that Charter rights were not meant to imply that those other rights that we couldn't have consensus on didn't matter. And Section 33 and Section 26 go together if that's the right interpretation of 26. And so far as Section 33, as our colleague Dwight Newman has shown in a book I edited, in a chapter he wrote in a book I edited called Constitutional Dialogue, he argues and shows, I think, very clearly that Alan Blakeney was one of the architects of Section 33 and emphasized rights outside of the Charter, like labor rights, the right to housing, as mattering and being part of what Section 33 affirmed. So in that reading, Section 33 goes with the idea that there should be rights protected outside of the Charter and what we've agreed on in it. And I imagine that Peter Lougheed, who has also helped push for the Section 33 as in the negotiations, would have probably had a different list of rights that mattered outside of the rights they could agree on to entrench in a Charter, but that they both agreed that the Charter wasn't the summary of all the rights that matter in public policy.
One of these foundational principles that I think, Leonid, you were alluding to is the principle of the religious neutrality of the state. And the Quebec government claims that Bill 21 is rooted in this principle. In your view, is this an accurate description? And further to that, is Bill 21 actually consistent with Canadian jurisprudence on the principle of religious neutrality? So Bruce, we'll start with you on this one.
All right. So two different conceptions, I think, of the idea of religious neutrality. One is to say that the state has an obligation to create sort of a safe space, safe public space for religious expression. And the other one, to say, look, as long as they don't interfere with what you're doing in your private time, that's religious freedom. It's almost the adoption of a secular government, a secular public space. Now, the problem with the first conception, in my view, is that if you treat it as an actual legal obligation, then you have turned religious freedom into a positive right. That means you're entitled to demand that the government take steps to clear a space for you to do what it is you want to do. And in my view, that is contrary to what the Charter freedoms are supposed to be. They're supposed to be negative freedoms that say, don't interfere. If you don't interfere, you've done your job. And that's my main concern about that version of religious neutrality. I acknowledge that being secular is not being neutral. And the choices that people will make in their own lives are theirs to make. But it's the best you can do, I think. If you believe that religious freedom is a negative right, then the insistence upon a secular public space, I think in some circumstances, like frontline workers, is the best you can do to get to a place which is religiously neutral.
Jeff?
I see it as a significant violation of religious neutrality in the sense that when the state does not accommodate religious free exercise, it is not being neutral towards religion. It is persecuting religion. It is discriminating against people based on their religion. So I'm confused as to whether or not Bruce is more convinced that the charter is not an issue, that his argument rests on the charter, not that Bill 21 is valid because the charter just doesn't apply to the provincial government, or if it's because it's just neutral and facially neutral and not subject to a 2A violation. Because to me it's clear that if a government prohibits people from wearing religious symbols directly and uses that language, not that they don't say, this law does not say your face must be uncovered. It says you will not wear religious symbols. It specifies and prohibits certain kinds of religious conduct. So it seems to me that it's clearly not neutral towards religion in the sense that it is targeting specific matters of free exercise. Unless you take the conception of religious neutrality as being that the state just should prohibit religious conduct amongst its employees so that it is entirely neutral and secular. You have to take a very strong conception of religious neutrality, of laïcité as your ideal of religious freedom for this to not be violating religious free exercise. And that's just not consistent with the charter jurisprudence and our conception and our own tradition of protecting religious free exercise as part of religious freedom.
So I mostly agree with Jeff. I want to add just a couple of context elements, I guess. One is about Quebec. I grew up in Quebec between the ages of 10 and 23. So I was there when things changed in the following way. So now we are asked to believe that this very, very far-reaching conception supposedly of laïcité, although there are at least some French laïcité scholars who suggest that actually Bill 21 goes beyond what French laïcité demands. But this far-reaching conception of laïcité supposedly is anchored in Quebec's history and traditions and in its struggle against the yoke of the Catholic hierarchy, all the way up to the 1960s. Funnily enough, nobody was actually talking about this supposedly deeply rooted conception of laïcité between, say, 1970 and 2006. So you would think that in the immediate aftermath of Quebec's liberation from what was genuinely an overbearing Catholic hierarchy for 200 years, you'd think that in the immediate aftermath, people would have been really concerned about the priests and the nuns making a comeback, and that over time, as that fades into history and increasingly out of living memory, people will become less concerned. That's not the story. The story is that actually the revolution, the Quiet Revolution, was so swift and comprehensive that nobody really worried between 1970 and 2006. What happens in 2006 is Multani case. So it's not about the Catholic Church suddenly reactivating its ultramontane tendencies. It's about a Sikh boy who wants to wear a kirpan inside his clothes when he goes to public school, and the Supreme Court, and based on the compromise that the school worked out with his family, and the Supreme Court says, yeah, this is a compromise that people should be able to live with, and certain people in Quebec, in particular the Québécois media owned by Pierre-Carl Péladeau, who was eventually the leader of the Parti québécois, those people have escalated a campaign of rabid hostility to minority religions, in particular, later on, in particular to Islam, but also to Sikhs and to maybe a lesser extent also to Orthodox Jews. So that's one contextual element about, is this part of a philosophically rigorous, acceptable conception of laicity. No, that's just a story that you're asked to believe that is not true. Second thing I want to say about neutrality, if we think that it's prima facie an interesting idea for people who are in the employ of the state to be neutral because it's true, right? It's a monopolist. There's no alternative, and I get that. But guess what? If when I go and I contact an agent of the state, I can tell that they are white or black or Asian or whatever. I can mostly, I guess, tell that they are a man or a woman. I can tell usually that they are, young or old, or they're a boomer. That's a horrible thing, isn't it? So I can see all of these things about them, and I think that decency requires us to assume, subject of course to there being some kind of evidence of bias on their part, but decency requires us to assume as a first initial impression that they are going to set aside whatever preferences or dislikes that they might have, and they are going to endeavor to interact with us honestly and in good faith. Again, that people are fallible, people sometimes don't live up to that. There should be mechanisms of complaint, there should be mechanisms of recourse against that. People should be sanctioned if they are not being neutral to us, and that's as true with respect to sex or gender as it is with, sexual orientation, age, race, whatever, and religion. But I don't think it's right to single out religion to say that, people who are identifiably Jewish or Muslim or Sikh, they are suspect. They are not going to be neutral, and I should have the right not to be faced with the fact that this person in front of me is a Muslim woman.
I want to be mindful of the time. We've got about 20 minutes left, so I'm going to ask one more question of our panelists, and then if people want to ask questions from the floor, they can start lining up to the microphone there on my right. And this really just kind of stems off the point that you were just making, Leonid, and I want to kind of gauge the other panelists' views on this. It's been suggested that Bill 21 embodies a distinct understanding of religious neutrality and secularism and laicity that is unique to Quebec. So to what extent should the rest of Canada just accept Bill 21 for what it is and move on? Or is this really about provincial autonomy, or is this an issue which all Canadians should be caring about? So, Jeff, we'll start with you on this one.
Well, like I said earlier, I substantively disagree with this law. I believe in speaking against it, but speaking against it and having this position, I also think that my views on how we should speak against it and how we should address it are related to my secondary view, my procedural view, that I think most of us should share, that we can reasonably disagree about rights in this country and democratically resolve our disagreements about them. And Quebec has used the Notwithstanding clause to enact what it sees as an alternative conception of religious freedom in its law. And I can substantively say that I see this as a violation of rights, while still engaging and talking to my interlocutor with respect and pointing out to them the substantive wrong and harm I see in what's going on. And I'm not going to get through to them if I call them racist or if I call them names and imply that that they are incapable somehow of valuing this thing going on, of seeing this harm that I'm talking about. And I think when I think it's interesting to see that when in English Canada, the rest of Canada, as Quebecers say, we've had Supreme Court decisions upholding provincial laws that violate religious freedom. Well, we don't need to go through them, but there's some significant high-profile ones, and the Canadian press has barely made a sound about it. But when Quebec does it, it's all of a sudden these racist Quebecers, and I just think that's an unfortunate aspect of the discourse right now, because it inhibits our ability to point out what I think is the substantive wrong here, which is that this law targets and suppresses religious freedom which is something we should care about in every province. And I just think that my procedural view about Section 33 and its proper use should go constructively to pointing out to Quebecers, not, oh, you use Section 33, you hate the Charter, you hate rights, you're racist. It should be, you did not use this the right way. You're using this to suppress a very important right that's enshrined in the Charter. And it's not just important because it's enshrined in the Charter, it's important because religious freedom matters. And when we talk about these, when we try to twist it, we see the way that our Charter might be twisting our ability to disagree about this reasonably by all of a sudden turning this conversation into how Section 28 actually really limits this, and this is really about sexual equality, and it's not really about religious freedom. I think that's another unfortunate aspect of the discourse going on right now. When we ask, what is the issue with regard to Bill 21? It's a violation of religious freedom. It's not about sexual equality. It's not about, I don't think it's about racism. I think that's a factor, but it might be a factor, but it's not the primary harm going on that we're concerned about and that we're disagreeing about.
Okay, I'll say a couple of things. One in response to Jeff's last point. Well, the reason why we are now reduced to, at least in legal terms, arguing in what may or may not be a somewhat twisted way based on Section 28, well, it's because of Section 33. It's because the government has foreclosed the proper avenue of argument, which I agree, it should be primarily about in religious freedom, but the government has shut that door, so, well, you know, people are trying to find a way around it. More generally to Chris's question, if we agree that we should have a Charter of Rights that defines a sort of a minimum standard of what is owed to individuals in every province, regardless of where they are, because they are individuals and because they are Canadians, then no, sorry, Quebec, you don't get to play that distinct society card. The Charter is there as a minimum standard for everyone. And now, as I said before, I think that the Quebec distinct society story in this case is made up. I think it's reverse engineered to try to excuse this thing. But even if it were not, the whole point of the Charter was to provide a set of constitutional guarantees that are not dependent on the province that you're in.
Bruce will give you the final word on this one.
Okay, so it's not because Quebec is Quebec, it's because Quebec is a province, and the province has jurisdiction. And if this falls within the jurisdiction and they've used Section 33, then the rest of the country should back off. That's their constitutional right. So, as I said at the beginning, I'm not a huge fan of the content of the law, but that's beside the point that it really should be, in my view, clearly constitutional. And just to make it clear, it's not about bias. It's not about their actions. It might be easier to view this not as a question of religious freedom, but a question of freedom of expression. Again, the concern is the liberty of the customer, of the citizen. It's like having a captive audience. You've got a government worker there making an expression. Let's say they have a big honking cross on them. If you're the customer, you're being made to engage in that transaction. And maybe all the bill is saying is that customers, citizens, should not be required as a captive audience to take in that message. Leave it there.
Okay. We've got about 15 minutes for questions, and I see we've got a good lineup starting. So I'm going to ask questions from the floor to try to keep their questions brief and succinct, and I'm going to ask our panelists to try to keep their answers to maybe under a minute each so we can get through as many of these as possible before we move on to our lunch break and the Runnymede Fellows presentation. So.
Thank you for the very interesting discussion. My name is Edward Choi. I practice law in Markham, Ontario. I have a question for you about, you mentioned that Section 24 may be applied if Section 33 is applied. I wonder what type of charter remedies you are thinking about, and what if the legislature decides to say no charter remedies, and you also mentioned that Section 33 should never be used. What if who's going to keep the courts accountable if the living tree has gone too wild, for example? And Dr. Pardy mentioned about the religious, that a customer or a citizen should not be a captive audience to see the religious symbols. But how would you define religious symbols? You talked about face coverings. What about something small, like a cross on the necklace or a pin like this, a cross pin? And how would you characterize religious symbols and a cultural symbol? Thank you.
So on Section 24, well, the legislature cannot say that charter remedies are excluded. The legislature cannot unilaterally rewrite the charter, except insofar as, so Section 33, and Section 33 doesn't allow it to rewrite the charter, is to shield the operation of a statute from the charter. Yeah, the legislature cannot just exclude all charter remedies. What remedies are available? Well, against a statute, it would be only a declaration, I think. I know that Dean Leckie has suggested that maybe you could get damages, but that has rightly or wrongly just not been, under any circumstances, I think, accepted that you could ever get damages for unconstitutional legislation. So assuming that that's part of our general constitutional principles that we applied, Section 33 doesn't change that. So it would only be a declaration.
So on Section 24, my take is this. You know the phrase, there's no right without a remedy. In other words, if you can't get a remedy, you don't really have a right. The opposite also applies. If you don't have a right, then you can't get a remedy. And if Section 33 basically says those rights are inoperative with respect to this statute, then what are you remedying?
That's not what it says.
Well, the argument is, to be fair, Bruce, the argument is, I think I might agree with you to an extent, but the argument is that the remedy is a right and that Section 33 doesn't apply to it. So it's a bit trickier than you're making it out to be.
Well, I don't think so, because if you give that reading to 24 and 33, that means you have severely undermined the role of Section 33 and made it not useless, but essentially make it a lot less powerful than I think it was intended to be.
You're going with what you assume to be the purpose of Section 33. I know Professor Saint-Hilaire has written quite eloquently about this as well in a blog post on Acquis de Droit, which is the University of Sherbrooke law blog. So it's an argument based on what is assumed to be the purpose of Section 33, to exclude the courts entirely from the equation so long as it's enforced. And I think that's just a misreading of the text. You cannot use the purpose to override the text. And the text doesn't say that the right is excluded or suspended. It says that the operation of the statute is shielded from the right.
Yes, and the statute breaches those rights and makes them meaningless. So we'll have to agree to disagree.
I think I'm overall with Bruce on this, mostly because I don't see. I think that the argument hinges a lot on, Section 33 doesn't apply to Section 1, therefore, but Section 33 doesn't apply to Section 24, so therefore, sorry, I'm getting confused. But when we say Section 33 doesn't apply to other sections, it doesn't just therefore follow. It's not clear to me what's going on with the it doesn't apply argument. So you could make the case that Section 33 doesn't apply to Section 1, so the court gets to then think about the operation as justified infringements or not. But that would push pressure on the conception of limitations we have under 1 and require us to sort that out. But do you see, I'm just not convinced by the first move in the argument that, Section 33 doesn't apply to 24, therefore remedies are right.
Should go to the next question.
I think we'll move on to the next question just because we've got a big lineup. So, and again, just for questioners to try to keep it as brief as possible. We've just got under 10 minutes and we want to try to get to as many people as possible.
Thanks very much to all of you for very provocative remarks. This is a question about Bruce's point about a loss of legitimacy or a crisis of legitimacy based on adventurism by the courts. But perhaps it's a question to the other panelists more. If, on the one hand, the kind of who dares wins approach has created a kind of anomie or groundlessness in terms of fixed principles or fixed reference points, and you don't want an abuse of a notwithstanding clause or other nuclear weapons. What is the minimum adjustment in terms of means or incentives or check powers to get a defense of fundamental rights without chaos among the branches in government?
Well, I disagree with characterizing 33 as a nuclear option. I think Jean Chrétien, Roy Romano, several people that were present at the negotiations of the Charter have all characterized 33 as this safety valve or nuclear option. But Romano aside, I think Chrétien opposed not having Section 33. He was on the other side of having it. So when he characterizes it that way afterwards, I don't think we should trust his view as that that's the purpose of the clause. I think one way to reduce uses of Section 33 is to reconceptualize and have a more constructive view of Section 1. So in Saskatchewan Case, one of the reasons the court found the funding for non-Catholic students at Catholic schools unconstitutional is that he characterized the constitutional obligation of Saskatchewan to fund Catholic students as a prima facie infringement of the Charter right to religious freedom and state neutrality under Section 1. And that just derails all of the court's ability to think reasonably about how to specify Charter rights. So maybe if we reconceptualize Section 1 and rethink some of the aspects of how to think about prongs of the Oakes test, we might have more reasonable interactions between courts and legislatures in this country.
I'm not sure I understood the question, so perhaps we can move on to the next one.
Sure, unless Bruce, you have comments. Okay, we'll move on to the next question.
Hi, my name is Ash Milton. I'm editor at Palladium magazine, although today I'm here in a personal capacity. My question has to do with, and Jeff, you've touched on this a bit, the difference between this French secularism and an English or Anglosphere secularism, where it came up in this discussion, I think. The religious practice is kind of being talked about in a personal liberty, a lifestyle choice, this kind of thing. And I think quite clearly the French form of secularism, as was also touched on, comes out of a context where the religious practice is much more bound up in institutional power, formal organization, ultramontane tendencies, and the like. And that is on its face like one difference, but the existence of things like Catholic school systems in Saskatchewan is also a result of the fact that there is this communal and social nature to religious practice. And I wonder to what extent there is just this like almost irreconcilable tension between a law which is viewing wearing a hijab or not, for example, as a purely personal choice rather than as participation in a community of belief that is institutional. Like, is there any way where that social reality can actually be recognized beyond maybe referencing something like multiculturalism, which still reduces this to a lifestyle? I would just make the point as well with Bruce's remark as sort of, do I have the right or not to deal with a person who is wearing a cross, say? Well, if we're viewing this in terms of people from certain communities, I don't see why the secular community, so-called, would be left out of this. Do they not just become a privileged group then within the state? So thank you again, and I look forward to your answers.
Well, I don't think that there is necessary tension. I think there are specific decisions of the Supreme Court that have failed to have regard to the communal aspects of religion. And Trinity Western, Hutterian Brethren are the two that really come to mind. But those were decisions that just went wrong. There were very strong dissents in both of those, and the dissents should have been the majority, but it's misapplication of the principle is court paying insufficient attention to religious neutrality. I don't think that those cases show that the principle of Anglosphere religious neutrality is in itself flawed and that it necessarily has to. I think we have to be careful. In a sense, the liberal state, which is not religious, has to see religious engagement as a matter of choice. If you want to disparage that, you can say lifestyle choice. Fine. But I think that the liberal state, can still respect that choice, including in its communal aspects.
I won't add much, just to point out that Trinity Western is a good example of the kind of thing I've been talking about. The Supreme Court totally wrecking the idea of the negative freedom of the freedom of religion. I mean, that's an institution, Trinity Western, religious institution, that should have the ability to open a law school. And yet the court twists the whole thing around, uses charter values to decimate the liberal idea and make it progressive. And if that's what you're getting out of the charter, then what are you trying to protect?
Anything to add?
I have nothing to add.
Okay. We'll move on to the next question. Asher.
Okay, well, thanks, of course, for a great presentation. My question is for Professor Pardy. I just want to drill down on your argument a bit. Okay, so I get the part about religious neutrality, and people have different conceptions of what religious neutrality ought to be. I just want to talk about this idea that the government as employer can't discriminate, or that if it does discriminate, that can't give rise to a charter claim, because I know you to be a textualist, and you come across as a textualist in this presentation. There's nothing in the text of the charter to suggest that state action is limited only to when the government is not acting as employer. And if that were the test, then the government could, expressly discriminate, say, against Jews or Muslims or Hindus, say no Jew can be in the public service, no Muslim can be in the public service. And it seems extremely unsatisfying to answer that, to simply say, well, the government's just acting as employer there, it's not the state, especially given the circumstances of 2020 Canadian society, which is that the government is so pervasive and such a pervasive employer. So is that your position?
Well, no, not exactly, but we have this difficult question that the courts really have, again, mucked up, and the question is, when does the charter apply? And we have the basic answer, of course, because it's in the charter, the Constitution itself, which is it applies to the government and not private organizations. But that doesn't answer the question in all kinds of situations, and this is one of them, right? So in Wall, when the Supreme Court was considering when courts could judicially review decisions of the government, they said, look, there are some decisions of the government that are not appropriate to review in the courts, and hiring is one of them, because it's a private decision. Now, if you can't judicially review a decision, are you still going to apply the charter to it? And I'm not sure what the outcome is, but let's put it this way. The government as employer is still subject to all the rules that employers are, including the Human Rights Code. So if the Human Rights Code prohibits discrimination, then the government is also prohibited from discriminating because it is an employer. And in this situation, I think that might be the most straightforward answer.
Unfortunately, I think we're going to have to cut it off there. We're right at 12:10, and we have a few logistical announcements that we have to make, unless any of our other panelists have 30-second responses. No, with that, I'll turn things back over to Mark with some announcements about lunch and the Runnymede Fellows presentation. Sorry to those that we couldn't get to your questions, but I believe all of you are going to be around for the rest of the day, and I'm sure you'd love to entertain some one-on-one questions. So with that, we'll turn things back over to Mark. Thank you to our panelists. It was a great discussion. It was better than I could have hoped, and it was very insightful. So.